Welcome to the Debrief, everyone. Let's begin with the trial of a Florida man accused of killing his wife and business partner. Mark Sievers, charged with being the ringleader behind the murder of Dr. Teresa Sievers. A colleague found Dr. Sievers beaten to death with a hammer in her own home. Husband Mark Sievers is on trial right now. Co-defendant Curtis Wright pleaded guilty and testified against both the husband and co-defendant Jimmy Rogers. A jury convicted Rogers of second-degree murder not too long ago. Wright was on the stand for a second day, this time facing cross-examination. Wright said he was a longtime friend to the defendant and that the defendant asked him to kill Dr. Sievers. On cross, the defense brought up an explosive question from Wright's police interview, where interrogators suggested Wright and the defendant, Mark Sievers, were in a sexual relationship.
For the next 3 to 5 minutes, Detective Levitt asked you about your sexual preference, didn't he?
Yes.
Objection, relevance.
Sustained.
Detective Levitt wanted to know if you had a sexual relationship with Mark Sievers, didn't you?
Objection, relevance.
Sustained.
That exchange came in the middle of testimony about relationship issues between the defendant and the victim.
When Detective Levitt told you that the Sievers were having marital problems, you told him, "You're telling me that they had marital problems? I was close, and I've never heard that. He never talked to me about that." Do you recall saying that to Detective Levitt?
Yes.
You said that Teresa was having an affair. Do you recall that? Do you recall saying that?
I recall saying that's what Mark told me.
And
I
you
wouldn't
said
know that.
Mark was concerned that she would take the kids if she left. Do you recall saying that?
Yes.
Okay. Where is she going to go?
Don't know. He said out of state, but specifically, I don't know.
Okay.
Cross-examination then turned to whether Curtis Wright wanted to use a gun to kill Dr. Sievers, to whether the defendant knew there was money in the house, and to the bizarre fact that Wright went to the funeral of the victim he says he helped kill.
And you said Mark wanted you to use a gun, is that correct?
That was his suggestion.
He also said that you didn't feel comfortable using a gun because you're a 5-time convicted felon, correct?
Well, I don't feel comfortable using a gun at all, but I wasn't going to carry one across, in my car because I am a felon.
But if you knew that there was a gun in Mark's house, you could have easily gotten code for the safe or could have tucked a key away for you, right?
Could have.
That didn't happen, did it?
Just said the reason I didn't use a gun wasn't because I didn't have access to one.
You know that there was nearly $50,000 in that home, is that correct?
I found that out later, but no, I didn't know that.
And then after the murder, you came down again for the funeral, is that correct?
Yes.
Having the mission completed, right?
Yes.
Did you ever get $50,000 in cash at that time?
No, our agreement was it would be paid after he got his life insurance payment.
The defense went on to ask Curtis Wright why he asked his neighbors to back him up if police came asking about his whereabouts around the time of the killing.
Did you ask your neighbors to lie for you?
No.
How did you get your neighbors then to sign these false affidavits?
Everything that was in those affidavits was true except for the 24-hour time discrepancy.
Okay.
And this was weeks after it happened, so
So-
I suggested that week and was the time. And
So basically what you did is you picked a set of events that was kind of memorable, specifically about working on a little mini truck, correct?
yes,
And then you just suggested to your neighbors that it was on days that it really wasn't, is that correct?
yeah, it was the day before.
You manipulated 4 of your neighbors into providing false testimony.
Yes,
And you did this because at the time you thought it was going to benefit you, correct?
I was protecting me, Mark, and Jimmy.
During direct examination, Wright told the jury his version of how Dr. Teresa Sievers died. In the gallery, the doctor's mother and sister struggled to control their emotions.
I panicked. I jumped up and I followed her into the house. I hit her with the hammer. Where I hit her at was she was turning to the right, not necessarily the back of the head, but kind of the side. I actually think that she thought I was Mark. She said, "Why?" Right after that the third time I swung, Jimmy came from my right side and just started blasting her over and over and over. I think she actually had one hand on the countertop, but he just kept hitting her, and then she ended up going down onto the floor. And after she was on the floor face down, he continued to hit her. When he kept hitting her on the floor, I asked him a couple of times, I said, "Jimmy, stop, is it enough?" And but he wouldn't stop, so I actually went over there and put my hand on his shoulder and just like stop.
And now to the testimony of another key witness, that colleague to Dr. Sievers who took the stand to tell the jury how he found her body.
Well, as I was walking into the house, so I would say as I'm stepping into the step leading into the laundry room, which leads into the house, I was calling her name.
And did you get an answer?
There was no answer. No.
So did you get a chance to get into the house and try to figure out where she was?
After I took a couple of steps into the house, it was obvious where she was.
And why was it obvious?
She was dead on the floor in the kitchen.
You were able to see her?
Yes, I was.
Can you tell me how you were able to figure out at that point that Dr. Sievers was dead?
Well, there was a lot of blood on the floor in the kitchen, a big puddle around her body, and she had this massive head wound in the back of her head, and she was cold and lifeless.
And so you touched her body?
Yes, I did.
What was the purpose of touching her body?
To check for any signs of life.
What's odd here is that the defendant is the one who called that colleague and asked the colleague to check on the doctor at one point. The colleague said the request was very strange.
The night before I found her, which would have been a Sunday night, I got a voicemail message from him saying that he was checking in on me for some reason, and wanted to know that if I was okay, and that Teresa was going to be coming home that night.
So how would you describe the fact that he called and left you this message the night before, checking on you? How would you describe that?
It was very odd, just very strange that he did.
Hey, Mark. This is Officer Mark. I'm just calling to check on you, see how you're doing. I was texting with Michelle, and she said you already made it back safely. And for Myers, I just wanted to... Anyway, you got the idea. I will talk to you later. Teresa comes back tonight, and then the girls and I will be back on Wednesday night. Just wanted to say hello and see how you're doing. Take care, Mark. Bye.
Earlier in the case, a detective talked about his conversation with defendant Mark Sievers about the death of Dr. Sievers.
Were you able to ask Mr. Sievers if he knew who had killed his wife?
Yes, I did.
And did he tell you who?
He stated he didn't know why anybody wanted to hurt his wife.
Did you offer him anything in exchange to even talk to you?
No, sir.
Was he threatened or given anything in exchange to talk to you?
No, sir.
You said you asked him for consent to search his cell phone. Was he threatened or offered anything in exchange for signing a consent form?
No, sir.
He did it of his own free will?
Yes, sir. He was free to go at any time, sir.
Also earlier in the case, the prosecution noted that none of the money Dr. Sievers kept in her home was missing.
How much money was within the house and where was it?
There were multiple locations within the house that there was money, but my total amount that I really counted was from the closet, which was the north closet in the master bedroom, which had the male clothing in it. There was 3 safes with cash in it, and there was also some cash in the office. So when I added it all together, it was just under $50,000.
Before we jump in with our guests, let's listen to this admonishment. After a lengthy cross-examination, the judge sent the jury out for a break and had this to say to the attorneys.
It's not my business if people want to beat a dead horse on each side, and I think both sides have made their point. But if you guys want to alienate the jury, that's between each of you. I think the defense made their point that there were that it was a redacted version or truncated version that was entered, and you said you're going to enter yours in during your case in chief, which is fine. But if you guys, I think you made your point with the first 10 and then the state yielded. State made their point with the 6,000 pages they mentioned. You want to go through this is fine. But I'll tell you what is my business, that we're going to finish this trial on time. And if that means we stay to midnight and I break my promise to the jury, I'm going to do it, because we're going to finish this trial on time. And if this is any indication of how every witness is going to be, pack your dinner, because we're going to start staying late.
Talking about the accusation from the defense that there are missing text messages in the state's evidence. Let's jump in with our guests here. Judge Brandon Birmingham and attorney Aida Leisenring. So Judge, what do you make of that admission? Is the judge the hero of all judges everywhere for the way he did that, or not?
Well, he certainly is mine. I loved it. I thought it was great. You've got to remind, these lawyers that the jurors are here because we're making them be here. And, he's right. There's no rule of evidence that says you got to do it quick. But so you've got to appeal to their desire to win and not bore the jury. I loved it. I thought it was.
Attorney Aida Leisenring, let's talk about that cooperating defendant's testimony. Curtis Wright, he's up there. He's self-admitting that I'm soft-spoken, and he's telling just a horrible version of this. Do you buy what he's saying? Do you think he's trying to minimize harm to himself? What's your read of his testimony and his body language?
Well, with cooperating co-conspirators, which, by the way, is one of the leading causes of wrongful convictions specific to death penalty cases, even when they're telling the truth, they're not necessarily credible people, but that doesn't mean their testimony isn't credible. And I found that he was pained by having to talk about what he did. I think he doesn't like himself for doing what he did, and that comes across, and that makes him credible.
Judge Birmingham, I'm inclined to believe generally what Curtis Wright says. Maybe a couple of the details are a little bit self-serving, but I got to ask, the cross-examination, did it really score the defense any points? Did it really suggest that the husband wasn't somehow wrapped up in this plot?
I think it made him be very incredible with the amount of time and effort he put in covering himself up. And, those are the points that he wants, that the defense attorney is trying to score with the jurors. Look, if he is this devious, if he is this misleading with everybody and covering up, then what in the world makes you think he's not going to be the exact same way with you to get what he wants out of this deal, which is to avoid the death penalty or whatever the charge is?
Well, that could be one possible explanation of it. The other possible explanation is that this was a calculated plot that was launched by a defendant, Mark Sievers, who manages a medical practice and presumably is meticulous because of that. So if he's meticulous with managing his wife's practice and everything else, he's going to meticulously be the ringleader behind a murder. That's another possible interpretation here, right, Aida?
Absolutely. And based on all the evidence that the prosecution claims she's going to be able to put before the jury, it seems he's just that.
So, Judge Birmingham, if we boil this all down, if you were the trier of fact in this case, Judge, if it was a bench trial, would you believe Curtis Wright or would you not?
I'm looking for all of the evidence that corroborates any involvement by the defendant in this case, cell phone messages, certainly the motive, the fact that there was other motives that were not expressed in this killing. There was $50,000 in cash that was left over. That eliminates a whole lot of people who just did this randomly. So, yeah, I think that the state has built a pretty good case circumstantially.
It seems to be that way, but keep in mind, we're still in the state's case. Things might shift when we get to the defense. We'll be back with the panel at the end of the broadcast, because still ahead tonight here on the Debrief. Attorney General Bill Barr speaks out about the death of millionaire pedophile Jeffrey Epstein. Also, reaction to the conviction of Henry Segura, the Florida man. A jury agreed killed his girlfriend, his son, and her 2 daughters. A look inside the trial strategy when we return. Attorney General William Barr is calling the death of millionaire pedophile Jeffrey Epstein a, quote, perfect storm of screw-ups. In an interview late yesterday with the Associated Press, Barr said Epstein should have had a cellmate when he died and that other systems should have been in place to ensure Epstein's safety. Barr also said that he understood why so many people used the so-called perfect storm of screw-ups as grounds for theories that Epstein died from homicide. Barr said good progress was being made on the Bureau of Prisons investigation into Epstein's death. 2 of Epstein's jailers now face their own criminal indictments over the matter. Another national case we're watching is that of Jerry Sandusky. The disgraced former Penn State coach received a new sentence of 30 to 60 years in prison for molesting boys. The sentence is the same sentence Sandusky received the first time around, but the laws used to calculate his original sentence have since been overturned. Sandusky will not be eligible for parole until he's 98 years old. Reaction now from the attorneys who litigated the quadruple murder trial of Henry Segura. As we first reported yesterday on the Debrief, a jury convicted Segura of murdering his girlfriend, Brandy Peters, his son, Javante, and Peters' twin daughters, Tamaya and Tanaya. Segura's first trial ended with a hung jury, just barely. It was almost an acquittal. This time it was a conviction, with Segura receiving a life sentence rather than the death penalty. Prosecutors John Fuchs and Sarah Dugan discussed the shovel the defense claimed was evidence of gang connections.
Full of children. The shovel was very small in size. We thought, it's just probably something that a child could have brought in at some point. It was obviously there before the beating of Brandy Peters occurred. Her blood was spattered on it. There was also dirt on the spade portion of the shovel, so it wasn't something that the cartel members had recently purchased and placed there as some type of, sign that they did this crime. So we kind of thought that theory didn't really make sense.
The prosecutors also discussed James Carlos Santos, who took the stand for the defense to claim he ordered a gang hit on victim Brandy Peters. If true, it would almost certainly mean Henry Segura wasn't the killer. Prosecutors said the jury was correct not to believe Santos.
Examination brought out the fact that he's just clinically diagnosed with having just grandiose ideas about who he is and what he does, and it's all delusional.
Everything he says has been inconsistent across the board. Further, the fact he's talking about 7 people were in the house that just didn't agree with the forensic science that came out of the house with 1 shoe print and 1 void pattern. So, quite frankly, everything he's ever said is inconsistent.
Defense attorney Nathan Price told Law&Crime why he opted for a 6-person jury rather than a 12-person jury. It's a strategy which ultimately did not work.
Last time the final breakdown amongst the jurors was 11-1 in favor of acquittal. And, I was contacted by one of the jurors after the last trial concluded, and she, kind of walked me through and explained what the process was and how it broke down. And once I knew, who the holdouts were, those were individuals that I had identified as people I wanted to strike the last time. I simply ran out of strikes. We thought that we would be more likely to avoid a hung jury and get a not guilty verdict if we went down to 6. We thought if I had more strikes than seats, that I'd be able to better control who made it onto the jury and therefore better control the outcome of the case.
That defense attorney also told us why Henry Segura asked that no defense be presented to mitigate a possible death sentence in the penalty phase of the case. This was a risky strategy, but here's the explanation.
Mr. Segura wanted a death verdict, not because he wants to die, but because he thought that would give him more meaningful review. And I don't think it would be appropriate for me to go more into detail than I did on the record regarding that issue, but that was the strategy there. As you probably know, people with death sentences get appointed representation all the way through every step of the appellate process, from direct appeal to post-conviction to federal habeas. They'll have representation appointed throughout the entire process. So Mr. Segura has never wanted to avoid a death sentence, and avoiding a death sentence was not considered a win by any of us by any stretch of the imagination. He wanted to go home and we wanted to bring him home, and that's still the goal now. There's probably nobody in the world more familiar with the facts of this case than I am, but at the end, with this particular jury, that didn't end up mattering. I know he's innocent. I wouldn't have taken his case if he was guilty.
But the jury found otherwise. Let's go back to our panel one last time. Judge Brandon Birmingham, interesting strategy when you get behind the scenes here. There's a lot of number counting and determining, hey, do I have enough strikes to get rid of people who might be problematic jurors? Well, when you eliminate the jury from 12 down to 6, you're also running the risk that you're not going to have one person to find reasonable doubt.
Yeah, but boy, those strikes, man, once you get towards the end, I always wanted way more than I ever had. And so you want to make sure that you just have people on the jury that are going to go with you. And if that's a strategy that he used with the information he had available at the time, then I'm glad he went with it.
You know, talk about a harsh shift here, though, Aida Leisenring. We go from 11 to 1 on a 12-person jury. One person wanted to convict, the rest wanted to acquit. And then we go down to this, where it's a 6-person jury, which they allow in Florida, and it results in a conviction. So I guess it really does boil down to who's sitting in the chairs.
Before we found out what happened, I said, why 6 jurors? Why did you consent to 6 jurors? And I thought it might be because of fears of a hung jury. Guess what? Take a hung jury. Take a hung jury the 2nd time, the 3rd time, the 4th time. And then if you get a sense that really it's overwhelming because every jury is different, then make that call after thinking about it. It really, I think, was one of the few mistakes that were made in his defense.
And Judge Birmingham, the rest of the strategy we heard there about not presenting any mitigating factors in the penalty phase of the case, because if you get a death sentence, all the appeals courts are just going to take that much closer of a look at the case. I've not heard that strategy before. What's your take on that?
Well, my take is it's disgusting if in our system that you get a better representation if you're facing one sentence versus another. A day in prison is just as equal as a life term in prison is just as equal to the death sentence. All of these need to be treated the same, and that's one of the biggest problems that we have in our system: disparate treatment for disparate sentences. It's sad. It shouldn't happen. We should have equal representation for any type of conviction that we have in our system. And
we should probably have equal appellate review as well, Aida, correct?
Correct. That said, facing the death penalty is very unique and it's different than any other case. So you do have to establish some defense. His defense was risky, but worked.
Exactly, and we know the outcome on this one. That's it for us this week here on The Debrief. Thanks to the panelists. We're out of time. We'll see you on Monday at 5.